Hello dear, in this video we are going to learn about the Judiciary Class 8 ICSE board, that is the Civics lesson 13. What are the parts we are going to learn in this lesson? That is first the Supreme Court, next functions of the Supreme Court, third part the High Court, and next one writs, then the Subordinate Court and the Legal Aid. Under Supreme Court, we have composition, appointment, eligibility, the term and the salary allowance and the power of the Supreme Court. Under the power of Supreme Court, we have four parts, that is original jurisdiction, appellate jurisdiction, advisory jurisdiction and the revisory jurisdiction. Then there is three functions of the Supreme Court, that is first one guardian of the Constitution, and the Supreme Court is the court of record, and the third one judicial review. We have three parts in the Indian Judiciary, that is first one Supreme Court, next High Court, then Subordinate Courts. Okay, let's see the structure of the Indian Judiciary. The judiciary in India is independent of the legislative and executive control. It interprets and safeguards the constitution. It also protects the fundamental rights of the citizen and settles disputes. The Supreme Court is the highest court of India. Below the Supreme Court are the high courts in the different states. Below the high courts are the subordinate courts. Composition of the Supreme Court. The Supreme Court comprises the Chief Justice of India and the maximum of 33 other judges. This number can be changed by an Act of Parliament. Appointments. The Chief Justice is appointed by the President on the advice of the Council of Ministers and in consultation with the other judges of the Supreme Court and the High Courts. The senior-most judge of the Supreme Court is generally appointed to the office of the Chief Justice of India. The other judges are appointed by the President on the advice of Council of Ministers and in consultation with the Chief Justice. Eligibility. To be eligible to become the judge of the Supreme Court, a person must be a citizen of India and must be an advocate practicing in the High Court for at least 10 years, or he or she must be a High Court judge for at least 5 years, or must be an eminent jurist in the opinion of the President. Term for the Supreme Court judge. A judge of the Supreme Court holds office till she or he attains the age of 65 years. He or she may resign from office by sending a resignation to the President of India. The judges of the Supreme Court can be removed from office on grounds of misuse of office, proven misbehavior or incapacity. This process is called impeachment. To do this, both houses of parliament have to pass a resolution separately containing the charges against the judge. This must be voted upon and passed by the majority of the total membership of the house and by majority of not less than 2/3 of the members present in voting. Salary and allowances of the Chief Justice of Supreme Court. The Chief Justice of Supreme Court draws a salary of 2.8 lakh per month. The other judges of the Supreme Court draw a salary of 2.5 lakh per month. Apart from the salary, the judges are entitled to free accommodation and other allowances as permissible by law. Next, powers of the Supreme Court. The Supreme Court hears and gives ruling on both civil and criminal cases as well as those concerning the Constitution of India. It enjoys the following jurisdictions, that is original, appellate, advisory and revisory. Original jurisdiction. There are certain cases that can only be decided by the Supreme Court. They have to originate in the Supreme Court and are thus known as original cases. Among these are disputes between the union government and one or more state governments, then disputes between two or more state governments, and the cases concerning the violation of constitution by the government or anyone else. In this way, the Supreme Court functions as a protector of our fundamental rights. Next, appellate jurisdiction. Appellate cases are those which are appeals against the judgment of the High Courts. As the highest judicial authority, the Supreme Court has the power to review the decision of the High Courts and give its own judgment. Next, advisory jurisdiction. In its advisory jurisdiction, the Supreme Court can give its opinion to the President on constitutional matters when asked for. However, the President is not bound to follow the advice. Next, revisory jurisdiction. In its revisory jurisdiction, the Supreme Court can review any judgment or order passed by it. This is done to rectify errors that might have crept into the judgment or an order. Then, functions of the Supreme Court. We have three functions: guardian for the Constitution, court of record and the judicial review. First, guardian of the Constitution. The Supreme Court acts as a guardian of the Constitution. It can declare any law null and void if it violates any of the constitutional provisions. It issues the writs or orders for the enforcement of the fundamental rights. Next, court of record. The Supreme Court records and prints all its proceedings and judgments. These judgments are referred to and cited by the lower courts throughout the country. Thus, the Supreme Court also functions as a court of record. Then, judicial review. The Supreme Court examines the validity of the laws passed by the Union and the states. It can declare any law null and void if it violates the Constitution. Then in the high courts we have 5 categories, that is composition, eligibility, term, salary and allowances and the high court's powers. The high court is the highest judicial body in the state. Some states and union territories share a common high court. For example, Kerala and Lakshadweep Islands share a common high court, the Kerala High Court. The National Capital Territory of Delhi has its own high court. The composition of the high courts. The high court consists of Chief Justice and other judges. The number of judges in the high court is decided according to the population of state. The President of India appoints the Chief Justice of a high court in consultation with the Chief Justice of India and the Governor of the particular state. The other judges are appointed by the President in consultation with the Chief Justice of India, the Chief Justice of that High Court and the Governor of the state. Next, eligibility. To be eligible to become the High Court judge, a person must be a citizen of India. Then he or she should have held judicial office in India for 10 years or more. Or he or she should have been the High Court advocate for 10 years or of 2 or more such courts in succession of the similar period of time. Then terms of the High Courts. Once appointed, the judge of the High Court can serve till the age of 62 years. He or she can be resigned earlier or can be removed through the same process that applies to the judges of the Supreme Court. Then salary and allowances of the High Court judge. The Chief Justice of the High Court draws a salary of 2.5 lakhs per month. The other judges draw a salary of 2.25 lakhs per month. They are entitled to other facilities and allowances as permissible by law. Next, High Court powers. The High Court can hear original cases such as those concerning the fundamental rights of a citizen. It passes judgment on election petitions and other election-related disputes. It hears appeals in both civil and criminal cases against the decision of the subordinate courts and can review their judgments. It controls and supervises the working of the lower courts. It also maintains the record of its proceedings and decisions. The lower courts can refer to those records. Writs. A writ is an order or direction from the courts ordering someone to do something or not to do something. Both the Supreme Court and the High Court enjoy the power to issue writs. Writs are issued for the enforcement of fundamental rights. Some such writs are habeas corpus, mandamus, certiorari, and so on. Then under subordinate courts, we have civil courts, criminal courts, revenue courts, panchayat courts, and lok adalats. Below the high courts are the lower courts that are subordinate to and under the control of the high courts. They are called subordinate courts. Civil courts. The court of the district judge is the highest civil court in the district. It has both judicial and administrative powers. The district judge has the power to try cases related to land, property, and so on. Under the court of the district judge are the courts of the sub-judge, additional sub-judge, and the municip courts. Next, criminal courts. The courts of the district and session judge, additional and assistant judges, and the courts of the first-class magistrates come under the criminal courts. The district and session judge may pass the legal sentence, but a death sentence has to be confirmed by the High Court. Appeals against the decision of the district courts are heard by the High Court. Next, revenue courts. All matters related to payment of revenue are heard in revenue courts. The Board of Revenue is the highest authority of all revenue courts in the state. Under it are the Court of the Commissioner of Revenue, the Court of Divisional Commissioner, the Court of the Collector or Deputy Commissioner, and the courts of Tahsildar and Naib Tahsildar. Panchayat courts. Panchayat courts are Nyaya Panchayats catered to the rural areas. 3 or 4 villages together have a Nyaya Panchayat. It tries petty civil and criminal cases and can impose fines. Appeals against its decision are taken to high courts. Next, Lok Adalats. Lok Adalats have been set up to resolve disputes in a simple, quick, and an inexpensive manner. They are presided over by a sitting or retired judicial officer. The disputing parties argue their cases themselves. The cases are solved through mutual understanding and compromises. Next, legal aid. Our Constitution tries to ensure that no citizen is deprived of opportunities of securing justice due to economic or other factors. Under the legal aid scheme, free legal services are made available to people belonging to the scheduled caste, scheduled tribes, women and children, mentally ill and physically challenged people, and all those who cannot pay for legal services.